Hello everyone, I am Purvika. I am studying MBA in Chanakya University. Today I am going to present about consideration in Indian contract law. Introduction. Consideration is an integral part of a contract. The rule of consideration states that it is essential to have consideration for a valid contract. The legal definition of the consideration is based on the concept of bargained for exchange. This means the both parties are getting something they have agreed, usually something for a value or something of value. According to section 2D of Indian Contract Act 1872 ICA defines the term consideration when at the desire of a promiser, the promisee or any other person has done or abstain from doing the promise essentials for the valid consideration. The consideration must move at the desire of the promiser. This implies that the consideration will only be valid when the promiser has required it. Effectively, any act done voluntarily does not constitute valid consideration. The consideration may move from the promisee to any other person. It is not necessary for the promisee to supply the consideration. It may move from any other person even if you are a stranger to the consideration. You can sue as long as you are the party of the contract. The consideration must be lawful. An illegal consideration is not valid and makes the contract void. The ICA declares consideration unlawful if it is forbidden under any law, if it is causes injury to the person or his property, or it is immoral.
Hi sir, I am Vivek. I am doing types of consideration. Past consideration. In case of past consideration, the promisor had received the consideration before the date of promise. Such consideration is called past consideration. Section 2D of the Contract Act uses the word as done and abstain from doing, which signifies such as consideration were made in the English law. Past consideration is now is consideration. Example: a bike is on the way up to the office. Is stopped due to the lack of petrol. A requested B, who has petrol seller. B gave petrol to him. Later, A promised B to pay 500 rupees in consideration of his past consideration. Present consideration. Present consideration is one in which of the parties to the contract has performed as part of promise, which constitutes the consideration for the promise by the other side. It is known as present consideration. In present consideration, both parties promise to perform their part of promise simultaneously. It is known as executed consideration. Example: you buy fruit from a vendor and immediately pay him the price. This payment is taken, executed, or present consideration. Future consideration. Future consideration is type of consideration in which one party performs is part of promise immediately, and the other party promises to perform is part of promise on a future date. It is also known as executor consideration. Example: A agrees to the supply wheat bags to B and B agrees to pay for them on a future date. The consideration is the future consideration.
Namaste, I am Vidyadhar. I am going to discuss about adequacy of consideration. Adequacy refers to the fairness of economic equivalence of consideration exchanged, while sufficiency means legal validity. Indian law does not require adequacy but mandates sufficiency. And adequacy is relevant in Indian law, but sufficiency and legality remains essential. Courts prioritize party autonomy unless public policy of fairness is compromised.
Hi, I'm Aishwarya. I am going to talk about exceptions to the rule no consideration, no contract. Section 25 of Indian Contract Act lays down exceptions where an agreement is enforceable even without consideration. The first one is love and affection. Under Section 25(1), if an agreement is made out of natural love and affection between close relatives and is in writing and registered, it is valid even without consideration. The second one is compensation for past voluntary services. Under Section 25(2), a promise to compensate a person for service already rendered voluntarily or at the promisor's request is valid without fresh consideration. For example, A helps B during an accident without any expectation of payment. Later, B promises to pay A for the help. This promise is enforceable. When it comes to promise to pay a time buried debt, under Section 25(3), a promise to pay a debt buried by the law of limitation is enforceable if it is in writing and signed by the debtor. For example, X owes 10,000 but the debt becomes time buried. X later signs a written promise to pay Y. The promise is legally enforceable. The fourth one is completed gifts. Explanation to 1 to section 25. A gift given voluntarily and accepted by the done does not require consideration. Once given, it is legally valid and cannot be revoked. For example, A gives B a house as a gift. Through a registered deed, B accepts it. The transfer is valid despite no consideration.
Hi, I am Gautami. I am discuss about the cases. First one is Weddell versus Atkinson. In this case, the Court of Queen's bench ruled that promisee cannot bring an action unless the consideration of the promisee moved to him. Consideration must move from a party entitled to sue upon the contract. No legal entitlement is conferred on third parties to an agreement. Next is the Chinnaya versus Ramaya case. In this case, an old lady by a deed of gift made over certain property to her daughter D under the direction that she should pay her aunt P a certain sum of money annually. The same day D entered into an agreement with P to pay her agreed amount. Later, D refused to pay the amount on the plea that no consideration had moved from P to D. Madras High Court held was P was entitled to maintain the suit as a consideration had moved from old lady, sister of P, to the daughter D. It was ruled that consideration need not to be moved from the promisee personally. To conclude this, consideration is an important element to fulfill the entire requirements of a legitimate contract. The failure of consideration would cause the cancellation of the whole agreement, but the statutory exceptions also cannot be ignored. It was very clear and expressly as long as the situations so explained above would fall in the exception to the overall rule of the consideration applicable general principles. Thank you.